I'm absolutely thrilled you're joining us today because we are diving headfirst into a concept that is literally the beating heart of our justice system. You know, we so often think of our constitutional rights as these grand, abstract promises just kind of floating in the air. But the reality? Procedural rules of evidence are actually the solid, concrete bedrock of those rights. Without these incredibly precise rules governing exactly how evidence is handled, well, your constitutional rights are really just words on a piece of paper. So let's kick things off with a question that has sparked massive, intense debates in courtrooms for over a century. Should a criminal go free just because the police blundered? It's a pretty provocative thought, right? Because on one hand, obviously, society desperately wants to catch criminals and keep our streets safe. But on the other hand, we absolutely must fiercely protect citizens from state overreach. I mean, if the police are allowed to break the law in order to enforce the law, what does that actually say about our free society? This is that inherent, delicate tension we are unpacking today. To navigate all of this, here's our roadmap for today. First, we'll look at the discovery and the exclusionary rule. Second, state versus private actors. Third, the fragile chain. And finally, secrets and digital evidence.
Section 1. Unreasonable searches and seizures. Tension in the discovery.
Okay, so there was this monumental shift in Philippine jurisprudence that we have to talk about. Under the old reality, which was guided by what's known as the Mancado rule, courts would actually accept evidence even if the police obtained it illegally. The logic back then was purely pragmatic. The criminal shouldn't be allowed to just walk free just because the constable made a mistake. But then everything changed with the landmark case of Stonehill versus Diokno. The Supreme Court laid down a bold new reality called the exclusionary rule. This rule basically says that all evidence obtained by unlawful searches and seizures is strictly inadmissible for any purpose, period. Why? Because the court realized that constitutional protections against unreasonable searches are totally empty promises if the state can just ignore them to get a conviction. The whole goal here is to deter official lawlessness by completely wiping out the incentive for police to disregard your privacy.
Now, of course, the law does recognize the fast-paced, practical realities of everyday police work. While the general rule is for sure that police absolutely need a judge-issued warrant, there are some strictly limited exceptions. We're talking about things like custom searches, searches of moving vehicles where a suspect might literally just speed away, the seizure of evidence that's resting in plain view, searches where you freely give your consent, searches incident to a lawful arrest, and the very famous stop and frisk. These specific exceptions set the exact rigid boundaries that police must operate within to balance public safety with your individual liberty.
And there's a really crucial difference between two doctrines that get confused all the time. And the famous People versus Malacca case is the perfect guide for this. See, a stop and frisk is just a limited protective search of outer clothing. It requires reasonable suspicion that a suspect is armed and dangerous, so it exists primarily just to keep officers safe on the street. On the flip side, a search incidental to a lawful arrest strictly requires a preceding valid arrest, which then allows officers to fully search the person and their immediate area. In the Malacca case, police arrested a man and found a grenade tucked in his waist simply because he was standing at a plaza with, quote, fast-moving eyes. Well, the Supreme Court ruled this entirely invalid. Having darting, fast-moving eyes doesn't constitute a crime, meaning there was no valid arrest to begin with. And there was certainly no justification for a stop and frisk since police didn't even see a weapon bulging from his clothes. So that grenade evidence, it had to be completely thrown out.
The Supreme Court actually captured this perfectly with this quote: "Lawmen cannot be allowed to violate every law they are expected to enforce." Simply put, an illegal search cannot be retroactively justified just because the police happen to get lucky and find a grenade or drugs. The legal process leading up to the discovery matters just as much as the final result. Section 2. State versus private actors. The Marty case twist. So let's look at an amazing plot twist. We're going to walk through the exact timeline of the People versus Martisi case. Step 1. A man drops off 4 gift wrap packages at a private forwarding agency to send to a friend in Zurich, claiming they just contain books, cigars, and gloves. Step 2. After the man leaves, the proprietor smells a very peculiar odor. Following his own standard operating procedure, he opens the package up for inspection. Step 3. He squeezes one of the gloves, feels dried leaves inside, pulls out a cellophane wrapper, and boom, discovers marijuana. He immediately calls the National Bureau of Investigation. And Step 4. The NBI agents arrive, are shown the open boxes, and officially take custody of the evidence. Notice the sequence really carefully here. The timeline proves definitively that the state was not the one who conducted the initial search. And this brings us to a massively vital legal distinction.
The Bill of Rights is a constitutional restraint directed only against the government and its agencies. It does not govern relationships between private individuals. So, in the Marty case, because a private proprietor opened the box on his own initiative with zero police direction or interference, the constitutional right against unreasonable searches simply didn't apply. The marijuana evidence was perfectly admissible against the sender. It's a stunning reminder that our constitutional protections are there to outlaw unwarranted intrusion by the government, not by your nosy fellow citizens. Section 3. The fragile chain: custody, drugs, and due process.
Now, how you handle evidence is just as important as how you find it. The law demands absolute perfection from law enforcement when handling evidence. This is where we have to talk about a major focus for us today: the landmark case of People versus Vallejo G.R. number 144656, decided on May 9, 2002. This case famously cemented the chain of custody doctrine, establishing that to guarantee the integrity of highly sensitive evidence, like DNA in the Vallejo case, every single transfer must be meticulously documented. This exact same rigorous standard is strictly applied under Republic Act 9165 for illegal drugs. There are 4 required links. Link 1, the apprehending officer must immediately seize and physically mark the drug. Link 2, it must be formally turned over to the investigating officer. Link 3, handed over to the forensic chemist for lab examination. And Link 4, the chemist must submit that exact marked drug to the court. This unbroken chain established by cases like Vallejo is literally the only acceptable method to authenticate the evidence and guarantee the item tested is the exact same item seized at the crime scene.
And the harsh reality for prosecutors is this: a single missing link breaks the entire chain. In cases like People versus Kamad, police committed flagrant lapses and couldn't even properly prove that the tiny amount of shabu offered in court was the actual shabu seized during the buy-bust. When the police fail to safeguard this chain of custody that the Vallejo ruling works so hard to protect, it creates a fatal gap. Serious doubt arises. And as the core legal rule goes, the constitutional presumption of innocence always outweighs the presumption of regularity in police duties. If the chain breaks, the court has absolutely no choice. The accused must be acquitted.
And here is exactly why we have these incredibly rigid rules. 30. That is the maximum number of years someone can serve under reclusion perpetua. We are talking about decades in a prison cell, the total loss of human liberty. When the stakes are this massive, we simply cannot rely on guesswork, assumptions, or sloppy police work. These strict rules of evidence are absolutely necessary to prevent innocent people from losing their lives to a technical error or, worse, planted evidence.
Section 4. Secrets and digital evidence. Privilege and cell phones.
Let's pivot slightly and look at a deeply entrenched legal secret: the attorney-client privilege. This is actually the oldest privilege for confidential communications known to common law. In the really complex Regala case, the court had to decide if lawyers could be legally forced to reveal the hidden identities of their corporate clients to the government. Well, the court ruled that under exceptional circumstances, like where revealing the identity would directly implicate the client in the very crime they sought counsel for, even the client's name is protected. This privilege exists for one reason: to ensure full, uninhibited trust in our adversarial system of justice. The court took a fiercely protective stance here, declaring compelling disclosure amounts to sanctioning fishing expeditions by lazy prosecutors and litigants, which we cannot and will not countenance. The court strictly protects the noble profession of law because, let's face it, the constitutional right to effective counsel would completely crumble if the government could simply force defense lawyers to act as informants against their own clients. But what about modern secrets? What happens when we move from physical spaces to digital ones, locked inside our cell phones? Let's trace the digital breadcrumbs in the People versus Hinojosa case. Step 1. A police officer is tragically murdered. Step 2. The suspects flee, but they make a massive, critical error. They drop a mobile phone right there at the crime scene. Step 3. The investigating police search the phone, read the incoming text messages, and actually use that knowledge to set up an entrapment operation. Step 4. The accused are caught and convicted based purely on these digital leads. Now, the defense argued that reading these text messages was an illegal search without a warrant, but the Supreme Court disagreed. The phone was abandoned evidence left at a crime scene, providing a strong, perfectly legal lead for police in hot pursuit to catch a killer. So as we bring all these incredibly diverse, fascinating cases together, what is the underlying core philosophy of our courts? It's that technicalities must take a backseat to substantive rights. Rules of procedure are not meant to be some kind of legal straitjacket that denies justice. They are essential tools intended to facilitate the attainment of truth and ensure fair trials.
When the state blatantly violates the Constitution, the procedural rules step in to protect the citizen. But when the state operates lawfully and diligently to solve a crime, those exact same rules ensure the guilty are rightly held accountable.
Let's wrap up this explainer with a final, really provocative thought for you to chew on. Is the price of a free society occasionally letting the guilty walk just to ensure the innocent are never, ever framed? It is a heavy, profoundly difficult question to answer, and it beautifully represents the delicate, vital balance our justice system strikes every single day through these rules of evidence. So think about that the next time you hear about a controversial case being dismissed on a so-called technicality, because it might just be your own constitutional rights hard at work. Thanks for learning with me today. Keep asking those great questions, and I'll catch you next time.